Thank you. That was an extremely nice and thoughtful introduction, and particularly nice since just a few minutes ago in his office I was talking about my ideal of the tuition-free law school. And after that, he not only turned 3 shades of white, then he introduced me as practical. I mean, quite amazing. So I think that was a very nice introduction, and I thank you for being here. The Caplins have given us just a wonderful tour of this beautiful, beautiful university. And look at that day. I mean, my goodness. And here you are. I don't want to remind you of that. But it's nice of you to be here, and also it is, actually I was talking about and he was talking about, Mortimer Caplin, this particular conference, which is a very important conference on public service. And I've spoken elsewhere about public service, and of course I do try to remind students, less need to remind students. Lots of need to remind students 3 years, 4 years out. 5 years, 6 years, desperate need, because you will become involved in the firm. And it's harder and harder to remember that Roscoe Pound called our profession a profession imbued with the spirit of public service. That's so easy to say when you're in class, and so hard to do when you have a family and bills to pay, and are there in the law firm day and night thinking about being promoted. So I say it's not so necessary to talk to you. It's necessary to talk to your employers. And if I do, they say, my God, that was a nice speech, is what they say to your face, my face, and they go right there, my God, what does he know about it, is what they think. All right. So I think it is a big problem. And Mortimer Caplin gave me a bigger quotation. See, my quotation bigger? Mine was 4 words, spirit of public service. His is bigger and probably better. He quoted Thomas Jefferson. There is a duty of service from every man, and he meant and women too, to his country, proportionate to the bounties that nature and fortune have measured to him. All right? Right, that was good. That's the person who founded this university. So I'm thinking, what can I say that will, in fact, better than that, stick in your minds 5 years from now? And the answer, of course, is going to be nothing whatsoever. But nonetheless, I want to try. And what will I talk about? I'll talk about the court, because that's what I know. I've been there 10 years now. 10 years, I've been the junior justice for 10 years. Absolutely. You don't know my special job? I get 1 vote like everybody else. By the way, I can bring people together. What do you mean? You can't unify them? All I have to say is we've been together for 10 years because we've reached perfection. They all agree. But my special job, and the only special job I have as the junior justice, is we are in a conference room about a quarter the size of this. We're there by ourselves. We sit around the table. We discuss the cases in order and go around and present our points of view and discussion. If somebody knocks on that door, it is my job to open it. The other day, somebody knocked, and they had a cup of coffee for Justice Scalia. I thought that was going a bit far. But I gave him the cup of coffee, and he said, "You've been doing this for 10 years." And I said, "Yes, and I've gotten pretty good at it." And he said, "No, you haven't." It's interesting. But our job, most of our job, not the whole thing, but a very large part of it, is to interpret this document, the Constitution. And after a while, and in this respect, I think our job is different from that of judges in other courts. Not that they don't interpret the Constitution, they do. But for us, it becomes a steady diet. And the fact that it is a steady diet tends to produce in each of us a kind of view of the Constitution as a single document. And so, when I'm asked to describe it in a few minutes, I can do that. And that's what I think is its genius. Right here in this state are the people who were the geniuses that put that genius into the Constitution. They said, what does this document do? The Europeans or the Asians or others in Latin America, they ask us quite often, what does this small document do? And I say, I can't tell you in one phrase, but I can tell you in 5 or 6. It creates a rule of law. It establishes a democratic form of government. It provides for separation of powers so that no one group of people becomes too powerful, a separation that's both horizontal between the branches of government and vertical between the states and the federal government. It protects basic human rights, and it provides a degree of equality, equal respect under the law. Now, if you think about it, most of its provisions fit right within that framework. And that's the genius of it. Because once you understand that, you don't have to be a lawyer or a judge or a Supreme Court justice to take those principles and run with them and implement them and carry them out and internalize them and apply them in all kinds of different contexts. It's possible to do. That's what we do, and that's what you do, and that's what millions of other people do. What I'd like to do in the next 15, 20 minutes is to take 2 parts of that I think are relevant to the theme of this conference. The lawyer's job, I put it very broadly, not to be simply a private practitioner. I'm not saying don't be one. I think it's great to be one. But I'm saying don't be only one. I mean, my friend Charlie Wyzanski years ago, who was a very good district judge and quite a brilliant person, used to quote Salvador de Madriaga, whom I didn't know who that was, except I'd met him once and he was very impressed that I'd heard of him. And he liked to quote, and the best thing this man said, or according to Wyzanski, was he said, he who is nothing but is not even. Now that's a great quote because no one knows what it means and it sounds extremely profound. But there is something to that. You are nothing but a private practitioner, maybe you're not even one, he said. And that's the theme. Now I want to describe a little bit of what I do or what I've seen on 2 of those 5 or 6 themes that I've mentioned in order to try to communicate to you really more emotionally than intellectually what this document is about, in particular in ways that concern you. So I'll talk first about the rule of law, right from the Magna Carta, right through here. And then I want to talk about a little bit the democratic objective of this document. All right, the rule of law. Now, to me, if I want to turn it into a personal and emotional matter, I think of myself sitting in the room, the Supreme Court chamber, where so much of importance to this country was decided. I mean, this is the room in which Brown versus Board of Education was decided. I didn't write in that case, but others in my position did, and that changed the country. And I still get quite a thrill, 10 years later, out of sitting in that chair and looking out across the room. Why? It's not just thinking backwards. It's also seeing in front of me people of every race, every religion, every point of view that is possible. And my mother used to say, there is no point of view so crazy that there isn't somebody in the United States who doesn't hold it. And since she was from San Francisco, she said, and they all live in Los Angeles. But nonetheless, I see that, and I've taken in, and you've taken in intellectually, and it's important to take it in emotionally, that the miracle of this country is that so many different kinds of people, from so many points of view, are in that Supreme Court chamber or the equivalent, resolving their disputes under law. And what I'd like to point out is that didn't happen by magic. And it didn't even happen just because somebody wrote those words on paper, whether it was Thomas Jefferson or James, it wasn't actually Thomas Jefferson. He wrote the Declaration of Independence. I know that. But it was, it was James Madison and others, and that wouldn't have done the trick by itself. They're brilliant words, but there are a lot of constitutions in the world with brilliant words. So when I want to teach, I'd like to teach 3 cases on this subject. I was a born professor, unfortunately, and I think of what are the cases. And the 3 right here that it seems to me make a difference, and I'll tell you in order. First, second, and third. First case, Worcester versus Georgia. How many of you know that case? Yeah, that's what I thought. That was true at Harvard, too. I got one person excellent at Harvard. It's 0. All right? That's very good. All right, now, what is that case, and why does it mean something to me? Now, I'll tell you in a minute. I'll identify the case, and you'll know it. This was a case that arose in 1832 or 33, somewhere in the early 1830s. And what had happened is that the Cherokees owned land in Georgia. It was guaranteed to them by treaty. It was their reservation. They had given up hunting and fishing. They were farmers. They had an alphabet. They had a government. They had a constitution. And somebody once found gold on their land. And when somebody found gold, the Georgians said, well, why should we let them have it? And they marched right into the Cherokee territory and took it. Well, the Cherokees, being certainly as conversant with the government of the United States as the Georgians, said, we'll do what any sensible people do in the United States. We'll hire a lawyer and we'll sue. And that is what they did. They got the best lawyer of the day, Willard Wirtz, former Attorney General, and he brought a law case, and it worked its way up to the Supreme Court of the United States. In fact, there were 2 cases I've been simplifying for purposes of exposition. Cherokee Nation versus Georgia, that was the first, and the Supreme Court found a way to get out of that one, some procedural ground of dubious merit, but they didn't decide it. But then what happened was a minister minister from Massachusetts came and was helping the Cherokees on their land, and the Georgians threw him in jail because he wouldn't take a loyalty oath to the government of Georgia. And he brought the lawsuit. And Wirt again ran in and represented him and said, the Cherokees own this land. The Georgians have no business putting anybody in jail for being on the Cherokee land. And there was no way the Supreme Court could escape deciding that, and they decided it. And they wrote Marshall wrote a fine opinion. And he said, this land belongs to the Cherokees. What are you talking about? Georgian law. Treaties, statutes, the responsibility of the federal government is clear under the law to guarantee to the Cherokee Nation this land that was set aside for them. And now I'll tell you why you've heard of the case. Because that is the case of which, supposedly, President Andrew Jackson said, well, John Marshall has made his decision, now let him enforce it. And Jackson sent federal troops to Georgia, to the Cherokee land. Why? To enforce the opinion of the Supreme Court? No. To evict the Cherokees. And the Cherokees were evicted from their land, and they marched across what is known as the Trail of Tears to Oklahoma, where their descendants live to this day. I mean, the descendants of those who survived that trip, of which there were few. All right? Keep that case in mind. Now, let us jump forward more than 100 years to a case that you will know about. And it is one of my favorites. It's called Cooper versus Aaron. I like Cooper versus Aaron. It's not as famous as Brown v. Board. It is not as important, perhaps, as Brown v. Board, but it is a very important case. And you'll remember that one because that was the case in which the governor of Arkansas stood in the schoolhouse door and said, I will not let the black children into this white school. And that was the case in which 9 Supreme Court justices signed an opinion and said, you could have had 9 justices sign an opinion, say you will enforce Brown v. Board. You could have had 900 judges signing opinions. You could have had 9,000 judges signing opinions. But I mean, how is that going to get the opinion enforced? But this time, the President of the United States, President Eisenhower, in an action that I think is really admirable and correct, obviously, sent troops to Arkansas, the paratroopers, and this time it was, in fact, not to defy the Supreme Court, but rather to enforce the court order. And the children did enter the schoolhouse. Those black children, who are grown today, they celebrate the event. I think they're around. And they entered that white school. So maybe Eisenhower had learned something from Andrew Jackson's unfortunate efforts more than a century earlier. Well, I like that case. And in fact, I was asked by a Russian paratroop general whom I was showing around the Supreme Court. I was showing him around because he had previously been in charge of targeting missiles, and at that time they changed the direction of the targets away from the United States, and the State Department said, show him around the court, we want to be nice to him. He asked me my favorite case, and I said, well, that's one of my favorite cases. And I said, shows, the judges and the paratroopers must be friends. But that's an important case. All right, let's jump ahead to the third case. Now here I'll say the third case is you take your pick. If you'd like, try Bush v. Gore. If you'd like, try prayer in schools. If you'd like, try abortion. Do I think all those cases were correctly decided? Well, I dissented in at least the first one. Are there a lot people who agree with me? Yes, some agree on one, some agree on the other. Do people feel strongly about those cases, abortion, school, prayer, Bush v. Gore, and a lot of others? You can bet your life they do. They feel very strongly, one way or the other. But the great untold story of Bush v. Gore is that there's no story to tell about the enforcement. There is no story to tell. It is accepted that that will be followed, as will prayer in schools, as will abortion, as will dozens or many other cases that are highly controversial and cases in which I cannot prove that I'm on the right side, nor can anybody else prove that they're on the right side. There is a lot to be said on both sides of virtually every controversial case in our court. Despite the fallibility of the justices, and despite the controversy of the issue, and despite the tremendous amount of emotion and feeling on all sides of such issues, well, perhaps the country has learned something after 200 and some odd years, because there is no question. There is no question. What? That those cases will be enforced. And what a blessing. Now, did I do that? Of course not. Did you? No. How did it happen? I mean, there's a long history. There's a history that includes a civil war, that includes 80 years of segregation, that includes all kinds of things, that right, wrong, and so forth. And is it the document that did that? No. Is it the individuals? No. I mean, it's more than the document. It's more than individuals. It is that what's happened is the country, and that doesn't mean just judges or just lawyers. It means millions of people have internalized the importance of following the law. That's the rule of law, not the documents. And so why do I bring that up? Because obviously it's your responsibility, just as mine, to try our best to see that that continues, because it doesn't happen by magic. It happens by teaching, by example. It happens in part by people noticing how people in public life act and how others act in response to their decisions. It's the public realm where, in fact, the lesson is learned. All right, let me turn to the second subject, which is related but different. And that is a subject that you hear a lot about, and I hear a lot about, and it's called what I think of as the thrust of this document. The thrust of the document, in my view, the thrust of the document is democracy. Now, that's not something everybody agrees upon. Quite not that the, well, I'll give you the specific example. Justice O'Connor, Justice Kennedy, and I were a couple of weeks ago at a meeting, and we were trying to we were discussing the subject of teaching civics to high school students, in part for reasons that you can understand. I think that's important. And they came up with a lot of surveys from lawyers in particular, very distinguished groups. The American Law Institute was one. What is the part of the Constitution that is the most important that we should teach first? And the overwhelming consensus was free speech. That wasn't our consensus. Among the three of us, we thought absolutely not. Is that because we're against free speech? Well, some think so, but I mean, we're not really. Why? Why did we have that reaction? Because we said that's not what's at the heart of this document. What's at the heart of the document is a form of government where people govern themselves. Lawyers have cases involving free speech, but that doesn't mean that's what's at the heart of the Constitution. Well, is democracy out of date? I'd want to illustrate to you a minor illustration, because it's only one tiny part, but it's something I see, how I think democracy works. One way it works in the United States of America. When? In 1789? No. Now. Today. All right? Subject. Let's take a subject. Let's take a subject that's controversial and complex where we really aren't certain what to do. I'm not talking about Iraq. Let's take, for example, a subject my former law clerk, Tim Wu, was interested in. Cell phones. The internet. Privacy. Free speech. Those cameras that now can be put all over the place in public places and can observe everything you do, just as the police can pick up every call that goes over that cell phone, and with the power of the computer, it can all be recorded. Well, what shall we do about that? Oh, let's ban it. Oh, good, ban it. Let's not have an internet. Let's not have cell phones. No, we're not going to ban it. What are we going to do? What are we going to do about this great intersection between free speech, print everything in the newspaper, and between privacy? I can find out anything about you and reserve it in a document on the computer forever. How do we legislate in that area? What kinds of laws ought we to have? I'm not going to give you the answer to that question because I don't know the answer. But I do know how we go about finding answers to such questions in this century now in the United States. Now there you're part of it. You're part of it because you love to go to these seminars where it's discussed. And you like to talk or listen. No, 2% like to listen, 18% large. But in any case, I love to say at the ABA they talk about these things. All the people who've come to this meeting talk about these things. And I say I love the American Bar Association. And I do, with its 400,000 members and 800,000 committees. But what's happening at those committees? They're talking about these things. And where does this debate go on? At meetings like that? In technical articles in journals? In the newspapers? Everybody under the sun tries to have an opinion. Good. The more that have the opinion, the better. And there's argument, you know, another topic which is we're seeing this happen is the terrorism, the Patriot Act. I mean, my goodness, read those papers, and newspapers, and you will see 14 criticisms and 13 defenses and everyone shouting about this, that, or the other thing. I say, wonderful. Wonderful. Because change comes out of that. People try something, they'll try an administrative rule, they may find it doesn't work, it may not work, then we'll try something else, we'll try legislation, and then at the end of the day, not at the beginning, if the system is working well, maybe our court will get involved. But if you think we have the answer, you're wrong. What we are asked to do, and that we try to do, and we hope for the best, is not to answer such questions, but to set the guidelines. That is to say, to interpret the constitutional provisions that will, in fact, give the democratic process leeway. It is the big, let's call it the rails on which the system runs, that it's our job to define the parameters, the outside limits. And we define it better, in my opinion, to tell you the truth, when the other parts of the government, when people all over the country, when the academy, when students, when lawyers, when experts, when business people, when engineers, when everyone else has had a lot of input in a complex question like that one. Because then we answer the question about the guidelines, i.e. the Constitution's outer limit, having been informed by the discussion and debate of others. So people who say, well, democracy is dead in America, I guess haven't been reading the newspapers. I mean, those debates go on in dozens of subjects, and I think that is what the democratic process today very much amounts to in a host of very important areas. Well, I say that's at the heart of the Constitution. Does it really affect the law? Does it really affect the issues that lawyers like to argue on free speech, equal protection, other parts of the Constitution? No, I think it does. I think it does very much. I mean, I'll give you an example, and I think it's an interesting example. And I'll say this is a pretty technical legal point, but it's an important constitutional point. We recently decided affirmative action, not exactly a non-controversial issue, in a case called Grutter. And in Grutter, the issue was whether affirmative action could be used under the Constitution's Equal Protection Clause by a law school for purposes of admission. And we ended up thinking that it could be used to an extent. And we tried to define that in the opinion. But I'm trying to show you how the democratic element enters. The democratic element enters the decision like that, I think, as follows. And it's an interesting way to me. We had two interpretations possible of the Equal Protection Clause. One interpretation, and I think I would favor that interpretation, it's a more purposive interpretation, says that this clause, the Equal Protection Clause, was primarily designed to help people who had been slaves and their descendants become integrated into American society, i.e. everybody else, the people who had been white and they were black. And that's what this is about. And that's what the Constitution is designed to encourage and to make certain there is no invidious discrimination. Well, an interpretation like that is going to treat differently positive discrimination designed to help from negative discrimination designed to hurt. But there is another interpretation. And the other interpretation says that phrase, equal protection of the law, means that the Constitution is colorblind. It means no distinction on the basis of color, whether it's pro-white, pro-black, pro-whatever, zero. It's just too dangerous to get into that business. It's too dangerous. People will be hurt, and who knows what will come of it. Now, I want you to see, and I don't have enough time, but I could if I had more time, I think bring you to the point where you would begin to think both of those interpretations have quite a lot to be said for them and quite a lot to be said against them. So how do we choose? Well, you go read the opinion. And what I found interesting in the opinion is this. It reflects what we were told in amicus briefs by many different groups. The Army filed a brief, and it said, we'd like to tell you something. we have a corps of officers that include a lot of minority officers, and they do their job. But we are not going to be able to recruit those minority officers unless they can get into West Point. And we still need a degree of affirmative action to bring them into West Point. And if you say the Constitution forbids that, we're telling you something. We can't run the armed forces of the United States. And the business community said exactly the same thing about major businesses. They said, unless you allow a degree of affirmative action in elite law schools and universities, we are going to have a very difficult time maintaining a top-ranking executive cadre that reflects more than simply the majority race in the United States. And they're serious about that. And they know what they're talking about. And so did other groups say that. And you can say, well, what has that got to do with the law? And I'll say, it has this to do with the law. I'm faced as a judge with a choice between two interpretations of the Equal Protection Clause. One is an interpretation that was purposive. The other is an interpretation that is colorblind. And I'm being told by people who know that if you choose the colorblind interpretation as the proper interpretation, we're telling you our institution is not going to work. And what we're really telling you is that the country is not going to work. Because you can't have a functioning democracy where vast numbers of people in the United States think that this government is not ours. So I'm being told that I must choose between an interpretation of the document under which our democracy that it creates as a practical matter will be capable of functioning, and an interpretation that makes that practical functioning far more difficult. Now, of course, I chose the first. I can't prove I'm right, but the court chose the first and wrote an opinion that basically reflects what I'm telling you now. Well, what is it I'm saying that's relevant to you here? I'm saying that as I see this document, it creates a democracy that's supposed to work. And I hope what my examples will lead you to conclude is that we in the Supreme Court don't make it work. Our job is to help maintain a system where you make it work. And by you, I don't mean you as law students, though that's part of it. And I don't mean you as lawyers, though that's part of it. I mean you as citizens. I mean, it is a system which I've come to know through the document, and I know what the document foresees. And what it foresees is basically people in the country participating in a government, participating in a government where people make decisions for themselves, not relying on the judges to make those decisions or anyone else. And does that happen? Well, I say, yeah. I've tried to give you some examples. Does it mean maybe you'll go in and out like Mortimer Caplin or Lloyd Cutler or Wild Bill Donovan, who created the the OSS in World War II and was a law firm partner? I hope so. I certainly hope so. Does it mean maybe you'll just participate in your school board? Great. Does it mean maybe you'll take an interest in public issues 5 years from now? I certainly hope so. Does it mean you want to go this far? I believe it, but you may not. I love what Pericles said. I read that somewhere. I'm not sure he really said it, but somebody said he said it. That he told the Athenians, he said, the Athenians in the 5th century, he says, Athens, a democracy. He said, what is it? What is it? What is it that we say about the man here in Athens who does not participate in politics, by which he meant government? What is it we say about that man? We do not say he is a man who minds his own business. We say he is a man who has no business here. That's tough. That's tough. But I think there is something to that, isn't it? All right, that's what I'm trying to show you. I'm trying to show you that this document and my job foresee, for reasons of maintaining what we have, a major commitment by you to not be just the law firm type, but you can do it, but not only, okay? Not only, that's all, not only. That we are a profession for a good reason that has a spirit of public service, and that is why I'm so glad you're here and why it's been a privilege for me to talk to you. Thank you.